All right.
Ready for okay. Mm.
What are you gonna call me today?
I was just thinking about it. It's not going to be that good, but I'm
Spicy.
here. Spicy, so spicy. Okay, we're recording. We're ready for this. Here we go. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined as always by my facetious co-host, Brett.
I'm not being facetious when I say that the sexy cigarette voice really works for you, Alice. You should smoke packs of cigarettes a day more often. It's you.
You know,
You got it
so many
going
people
on.
complain about my voice that it sounds apparently feminine. I'm just kidding.
Decided to
I'm
gruff it
reading
up a little
between the
bit.
lines that
Yeah.
people don't like my voice because it is a feminine voice. I thought I would smoke a pack today.
Mm.
Just kidding. I'm deathly ill. But even if I'm deathly ill, I still love me some puns. And that was
Yeah.
a pretty good one
Yeah.
because facetious is one of my favorite words, but that's not what
Yeah.
we're talking about.
Yeah, we had to get this recording in before Alice passed on to the next world. So this might be the last one. Hope you guys enjoy it. We'll see.
It's
But
been good
yeah,
knowing all of you.
it's legal brief. So there's just so much legal news out there. People have been asking us to cover all sorts of stuff. And in the news, I'm sure a lot of you have followed this. There was an indictment handed down against several protesters and journalist Don Lemon for their involvement in a protest inside a church during service. And this was under something called the FACE Act, which we're going to talk about. And people had a lot of questions about how that works, what the statute actually does, sort of how it compares and combines with the First Amendment, what the fact that Don Lemon is a journalist, if that has anything to do with it. So we thought we'd go through the FACE Act, do some very high level First Amendment discussion, and then read for you the indictment so you can decide for yourself if the facts in the indictment are proven, given what you'll learn about the law. Is this something that someone should be convicted of, or is it potentially an overreach by the government?
Yeah. So this is very much a listener participation sort of thing because most of you probably have not really heard of the FACE Act until it was all over the news over the past week or so. So, what is the FACE Act? You know, Congress, like yours truly, loves a good acronym or pun. So, the FACE Act stands for Freedom of Access to Clinic Entrances Act, and it's found at 18 USC Section 248. And it says that by force or threat of force or by physical obstruction, intentionally injures, intimidates, or interferes with, or attempts to injure, intimidate, or interfere with any person lawfully exercising or seeking to exercise the First Amendment right of religious freedom at a place of religious worship. Now, some of you may be thinking, what does that have to do with clinic? Well,
It's a great question.
It's a great question because a lot of people were wondering that. The FACE Act, although it's known as the Abortion Clinic Protection Act, actually has another section to it in the title, in fact, but it didn't fit within the beautiful acronym of
exactly.
FACE.
It's the acronym.
It's all for the acronyms.
Yeah.
So it's actually also an act that applies not just to First Amendment rights with respect to abortion clinics, but to religious houses of worship and your First Amendment right to enjoy that freedom of religion.
And what's interesting about the amendments, in some ways, they're not self-executing. I mean, they include sort of a general description of your rights, but in particular, when you think about the amendments initially just applied to the federal government. They didn't apply to the states. They did not apply to the states until the 14th Amendment. Basically, if you think about, we need to do Dred Scott, but think about the history of the United States. The states started off very independent, as we've talked about many times. You had the issue of slavery. You had the issue of property rights, of due process rights, of citizenship, all these different things that were contained in the first 10 amendments, the Bill of Rights, but they didn't apply to the states. They actually only applied to the federal government because the drafters of the Bill of Rights, their big concern was federal government overreach. So when they did that Bill of Rights, it was all about the federal government. The First Amendment, the first part of the First Amendment is Congress shall make no law respecting the establishment of religion or abridgment of the free exercise thereof. I forget exactly how it goes, but the establishment of a religion thing, when that was written into the First Amendment, several states had established religions, and that was fine. The states had established religions, and they didn't want Congress saying, no, we're going to have one national religion. It's going to be Episcopalian, or it's going to be Catholic, or it's going to be whatever. They didn't want that. They wanted their states to be able to have theirs without interference. Well, then we go through the pre-Civil War period. We go through the Civil War period, and there's this recognition that we need these rights need to apply to the states. So you have the 14th Amendment. And the 14th Amendment, really, the whole purpose was to apply the amendments to the states. Then you immediately have the Supreme Court say it didn't do that, and that's Plessy versus Ferguson, right? And that was crazy. And then this is all on the side, but then we have to like make up a way to apply it in the states, which we've called incorporation. So you have this whole incorporation doctrine. They have to be incorporated. It's bizarre. But the long and short of it is they should all apply to the states, and the big ones do, right? So the First Amendment now applies to the states. But Congress in the 14th Amendment is given the power to pass legislation to sort of define how these rights are applied. So you think about the First Amendment, rights don't tend to be unlimited, particularly when they interfere with other rights or other people's rights. So what you have here is, we're a protesting nation. We've been a protesting nation for a long time. It's deeply ingrained sort of in our culture.
Kind of how we started.
Kind of how we started. Exactly. Okay, that was
just kidding.
Wow,
I just did a little dig.
Okay,
just did a little dig.
Yeah, maybe go back to mute, Alice. Anyway, but the problem with that is obviously protests can interfere with other people's rights. So in the 80s, there was this issue with abortion clinics. So you had these abortion clinics and you had people protesting, and the protesters got closer and closer until the point that they were actually blocking the clinics and people couldn't get into them. And there was this concern about that. And so at some point, the FACE Act comes around, and it kind of ends up being a little bit of a compromise. So there's the people who are really concerned about that. There's the people who are concerned about counter protesters at places like crisis pregnancy centers, which tend to be not abortion, but sort of all the other options for pregnancy. And there were concerns about the ability to practice your religion free of protest. And so all this gets lumped together into this FACE Act, which is then passed to protect these rights and to balance people's rights to free expression of religion versus the First Amendment and all that other stuff. So that is the whole point of this, and it's why it has become relevant now. Just because just because that's what Congress wanted to do doesn't necessarily mean that the FACE Act would be constitutional. So how do you decide if something that arguably infringes on the First Amendment? I mean, you have the right to free speech. Well, this limits that to some extent, right? Even if it limits it for good reasons, and even if it limits it because you were impacting other people's free speech, still limits it. So how does the Supreme Court decide whether it limits it too much? Well, there's been a lot of cases on this. One that really got into it is a case called Ward versus Rock against racism, which is 491 U.S. 781. It's a 1989 case. And it's not the first one to talk about this, but it's one that really kind of wraps everything together. And it's a landmark case on this issue. And it talks about how when you have these restrictions like the FACE Act on potential First Amendment expression, there's going to be several different things you have to make sure it allows. Number one, it has to be narrowly tailored. That means it can't be overbroad, right? Now, it doesn't have to be the quote unquote least restrictive means, but it has to fit well with what you're wanting to do and sort of accomplish that goal. We've talked about this when we talked about gag orders, right? Gag orders restrict your right to speak. But the Supreme Court has said, because it protects a defendant's right to due process, this is another one of those balancing areas. We're balancing two competing rights. And we talked about how they have to work. If they don't work, then you're sort of limiting your speech for no reason, right? And they can't be overbroad. The one in Arkansas that was recently struck down in the Aaron Shepard case we talked about was overbroad. So they have to be narrowly tailored. I don't know if do you have anything about narrow tailoring, Alice?
No,
Tailoring.
these are my cough drop as I spit it out.
Mm.
These are all considerations that, and many of you listening, especially if you haven't been in First Amendment law, not a lot of people practice in First Amendment law, are thinking, these are a lot of words. What do they mean? And how do you actually draw the lines with these? Good question. Hence, all of these cases, right? Narrowly tailored. What does that mean? Basically, the Supreme Court is grappling with the fact that these are important rights and we want to make sure we're protecting them. So we're like working with a scalpel with respect to these sorts of arguments. First Amendment case law is going to continue probably for time memoriam because of the fact that these words, what do they mean? And the reason we splice and dice them so narrowly is because we care so much about the First Amendment. We want to make sure we don't paint with a broad brush.
And look, it's swung back and forth. I mean, your rights, your free speech rights have been broad and they've been narrow. And, you know, right after the Constitution was passed, you had the Alien and Sedition Acts, which was pretty clearly a pretty large violation of free speech rights. Then you had statutes in the early 1900s that criminalized communism. That you've probably heard the old phrase, you don't have a right to say cry fire in a theater or whatever. And people always repeat that. And they don't realize they're literally quoting from a Supreme Court case, upholding laws against preventing people from being able to espouse communist beliefs. Like, no one thinks that case is rightly decided, but everybody quotes that line. And it's just a good example of how you can use a line. Oh, that sounds right. You know, oh, yeah, nobody has the right to shout fire in the theater. That makes sense. Therefore, you can't be a communist. I don't know about that, but that's, you know, once again, Oliver Wendell Holmes, in my opinion, one of our worst justices, like most anti-freedom justice we have, wrote that. He was a great writer and wrote that line, and people are quoting it to this day in the 21st century when they talk about free speech. Anyway, so this is always developing. It's much broader now than it has been in the past. Content neutrality. Content neutrality is one of the most important things, and it's something I really want us all to focus on as we're talking about this, because we're about to get into this very controversial, very personal case that people have strong feelings about. And the thing about restrictions on speech is the content of the speech, the purpose of the speech can't matter. It can't be that we allow speech we like, we disallow speech we don't like. That is the rock on which freedom of speech is built. So when you think about this case, I want you to actually do this as we're going through this. Like I said, people feel very strongly about this. Try and divorce this from the actual issue. You know, if you're someone who thinks ICE is great and you're like really mad that Don Lemon and these people did this, try and think about a different issue you don't care about where people did the same thing.
Like a Save the Whales protest.
Exactly. Now, maybe you care about whales, but, you know, if you don't care about whales.
Today, it's a little less, less spicy than ICE.
Somebody, the Bears are about to move to Indiana, maybe. So you're a big Bears fan, or they're Bears fans who show up at the owner's church to protest moving the Bears to Indiana. I don't know. Just try and think of something that doesn't excite a lot of passion in you to try and think about this as we're walking through this and whether or not this conduct is wrong. If you're someone who thinks that ICE is terrible, you know, and so then maybe your natural inclination is to be on the side of the protesters because you believe, you agree with them. Try and think of the opposite. Like if these were pro-ICE protesters showing up at like a Catholic church where the parish priest has been giving talks about immigrants and bringing in immigrants, and, you know, how that's like what Jesus would want or whatever, or like a Universalist church which often have very strong pro-immigration positions. Imagine if it were people on the other side showing up at one of those churches to do the same conduct. And I'll give you a great example of this from a movie. So some of you, many of you, most of you have seen A Time to Kill, when Matthew McConaughey gives the most amazing, inappropriate closing that should have been struck and he should have been sanctioned and probably had his bar license pulled for. But at the end of the movie, he just gives this incredible speech, right? And he's this jury nullification thing that he's doing. And he does this whole speech about this girl, and she was black and she had been raped and brutally murdered. He gives this whole speech, and he gets to the end, and he says, "Now imagine she was white." And the reason he's doing that is because he wants this jury, who might be naturally inclined to be sympathetic to the two white victims, to not well, the white victims of his defendant who killed them, because they're the ones who killed his daughter, in case you missed the movie. So he thinks this jury is going to be naturally sympathetic to them, so he's trying to flip that on its head, by take the victim and inverse the situation to a situation you might be sympathetic, and think about it that way. And I think you have to do that here with this whole content neutrality thing. Try and do that with yourself. And then the last prong of this is leave open ample alternatives for communication. So it can't ban protest altogether. So for instance, abortion clinics, oftentimes there will be an area sort of set back from the entrance of the clinic.
Zone.
A buffer zone.
It's called the buffer zone typically.
Exactly. Where people can protest. And so that would be an option. Or there might be, you can have a march, or you can do whatever. And that's an alternative way to protest. And the fact is, the FACE Act has been challenged multiple times and has been upheld in circuits across the country, including the 8th Circuit, where Minnesota is. I don't think the FACE Act has ever gone to the Supreme Court. I could be wrong about that.
No, I don't think it has, because it was only passed in 2000 something. It's a relatively newer act, right? It's with
it's relatively new. Yeah,
well, all the abortion clinic protests. So, with that said, now remember, we're going to read to you the complaint here, but try to divorce it from what the protest is. Right now, obviously, one of the hottest topics in like the entire country, probably the world, is ICE. But here are the allegations from the indictment. After the service commenced, a group of approximately 20 to 40 agitators, including all of the defendants named in this indictment, entered the church in a coordinated takeover-style attack and engaged in acts of oppression, intimidation, threats, interference, and physical obstruction alleged herein. As a result of defendants' conduct, the pastor and congregation were forced to terminate the church's worship service. Congregants fled the church building out of fear for their safety. Other congregants took steps to implement an emergency plan, and young children were left to wonder, as one child put it, if their parents were going to die.
So that's the top line allegation in the indictment. And one thing we're going to go through, we're just going to read the indictment to you. So we've given you sort of that's a pretty simple act. I mean, I'll just go back through it. Basically, the elements you'd have to prove: by force or threat of force, or by physical obstruction. So that's the first thing. So it either has to be force, threat of force, or physical obstruction. Now, you may be thinking, we just talked about violence. What's a crime of violence? What's a threat of force? Okay, so the courts have generally said threat of force means, would a reasonable person, it's the reasonable person standard again, a reasonable person in the situation, in the church pews, have felt as though what was going on was a threat of force. Physical obstruction is a lot easier, honestly. I mean, you're going to see the allegations in this are that they filled the aisles, people couldn't get out, they couldn't do anything. So that's the first thing. It has to have one of those. Then it has to have intentionally, so it has to be intentional. Intentionally injures, intimidates, or interferes with, or attempts to injure, intimidate, or interfere with. Pretty broad. I mean, and you see, this is the way a lot of statutes are. They start narrow and then get broader. So injures, that's pretty narrow. You got to show something pretty specific. Intimidates, a little bit broader, but still, I mean, you got to be intimidated. Or interferes with. I mean, interferes with is pretty broad, right? And then, even if you failed at all three of those, if you attempted to do it, good enough. With any person lawfully exercising or seeking to exercise the First Amendment right of religious freedom at a place of religious worship. So basically, you got three: force, physical obstruction, threat of force, injures, intimidates, or interferes with, or attempts to do so, someone in their sort of religious endeavors. If you're a defense attorney, you're probably going to stipulate to the third. Everybody agrees this is a church service, right? So it's really going to be about those first two things. An interesting sub-question of this is, Don Lemon is a journalist, and what difference does that make, if it makes any difference at all? And I will say this, the court's been pretty narrow with any sort of special journalist protection, right? So like, if if you have a source, if you're a journalist, you have a source, you don't give up your source, you go to jail. They hold you in contempt of court, put you in jail, right? There's no like journalistic right to protect a source. So usually it basically overlaps with free speech. If the journalist would have a free speech right, then they're good. But being a journalist doesn't do a whole lot for you in these cases.
And it's an interesting question because then you have to take it a little bit further. Like if you are a journalist, it's not a blanket protection if there were some special protections, if at all, right? It's if you are working in journalistic endeavors at the moment, because you can imagine if there's this like too broad of a blanket, everyone can just claim to be a journalist. And in fact, in this day and age, we've talked a lot about this. The media
We're
world,
journalists.
we're
right?
journal. I mean, quite literally,
Right.
we've applied for journalist passes because we cover news, right? And so what, first of all, like what is a journalist? And this may be why the protections of journalists really pretty much mirror just First Amendment protections, is because what is a journalist? How do you basically decide when you're a journalist versus just a citizen? And it could become a shield that essentially renders any sort of First Amendment protections, moot, if enough people just throw it up as a shield to say, I can do whatever I want because I'm a journalist.
I mean, I'm still waiting on my press passes from the Alabama
It's coming.
Athletic Department. So I don't know when I'm going to get it. But
Any day now.
given how
Any
much
day
I
now.
talk about it, I feel like I need to have courtside.
I'll work on
access.
that for you. I'll work on
Thank
that
you.
for you.
You do
I'll
that.
just
Yeah,
stand
do that.
outside. I'll
Like,
just stand outside and wait.
Um,
Okay. Shall we read this?
Sure, let's read it. So here's what we're going to do. We're going to read this indictment for you. You now know you're the jury, right? You know the law. We've instructed you on the law like good judges. You know what you're looking for. I'm going to read you the indictment. And the way you should judge the indictment is if the government can prove all the different things in the indictment, is the defendant guilty? So we may read things in the indictment that you don't think are true, and that's fine. That's fine. For the purposes of this exercise, though, let's just go through the indictment and decide if it were true, are they guilty? And then, and why is that important? Because if the answer to that is yes, then the indictment itself is at least legitimate, right? Like some people have questioned, is this a political indictment? Is this a political attack? It may very well be, right? But the question for sort of a grand jury, for instance, considering this is, if these are true, are they guilty? Is there some probable cause to believe they're true? That's what they're finding, right? Now, we may get to trial. We might get to a probable cause hearing. We might get to any number of hearings where the facts alleged in the indictment turn out not to be true. And that obviously will be a different situation. But let's just read to you the indictment, and you guys can decide for yourself what you think. Okay? Okay. So Alice is barely hanging on. So I'm just going to do most
I got
of the
this.
reading.
I'm going to read. I can read. I got
Okay.
this. And when I stop,
read.
when I keel over, you just take over, right?
So we're going to skip the introductory allegations because we
already
read those
basically did that.
That's what we read to you. So this is a conspiracy. So basically, they've alleged that all these people have conspired to violate the FACE Act, right? And what's great about a conspiracy is whenever you have a conspiracy indictment, it's a speaking indictment. So you lay out sort of all your allegations.
And so those of you who have heard Don Lemon was arrested, he was, but along with 8 other people. And so this indictment started with the kind of intro that it was a spicier intro than, you're allowed to do that because it's a speaking indictment, but you just heard what they started with. The first count is a conspiracy count. So it's for 18 U.S.C. Section 241, conspiracy against the right of religious freedom at places of worship. It starts with beginning on an unknown date and continuing to on or about January 18th, 2026. Just by the way, that's how you write all indictments, so you can cover the possible dates. In the state and district of Minnesota, that is to establish why we are able to come to this court. The defendants and they list all of them here, including Don Lemon, conspired and agreed with one another and with other persons known and unknown to the grand jury to injure, oppress, threaten, and intimidate multiple persons, including the clergy, staff, and congregants of the city's church, in the free exercise and enjoyment of the rights and privileges secured to them by the laws of the United States. And because of such persons having exercised such right, namely exercise of the First Amendment right of religious freedom at a place of religious worship, as secured by Title 18 USC Section 248C, all in violation of Section 241. So that's the introduction of the Conspiracy Act. Just so you know, that's essentially a recitation of the elements of the crime, which you have to do. You have to allege every element of the crime in order to pass a motion to dismiss phase.
And as you guys learned in our last legal briefs about Luigi Mangione, oftentimes what you see are different sections of the federal code working together to create the charge. So here you have United States Code 248C. That's the FACE Act. That's the section we read you, right? But it's also a conspiracy. The conspiracy is 241. It's a 241 conspiracy against rights. So you have a conspiracy against your fundamental rights, your civil rights, and the statute that defines what those actions against your rights were is 248. These two work together, and you have the charge of conspiracy. Okay, manner and means. I'll read you the manner and means. In order to achieve the object of the conspiracy, defendants Armstrong and Allen. So there's a lot of people you never heard of because they're just activists who were there. I mean, Don Lemon sort of gets all the press, but there's a lot of people who were charged in this. Together with other persons unknown to the grand jury, which isn't that uncommon to have unknown people.
You do this so you can amend it later if through your investigation more, and you don't have to start from scratch, because this leaves open the ability to amend.
Right. Together with other persons unknown to the grand jury, organized the operation targeting the church, which they dubbed Operation Pull Up, and promoted it on the internet via Instagram accounts. All defendants met at a shopping center for a pre-op briefing, during which Armstrong and Allen advised other co-conspirators, including defendants Kelly, Lemon, Richardson, Lundy, Cruz, Fort, and Austin, about the target of their operation, City's Church, and provided instructions on how the operation would be conducted once they arrived at the church. Once at the church, all the defendants entered the church to conduct a takeover-style attack and engage in various acts in furtherance of the conspiracy. This is a conspiracy. What is it? What do you have to prove to show a conspiracy? You have to show an agreement between two or more people to commit an unlawful act, right? So what they're showing you here in this very opening thing is we had an agreement. We all met at wherever they met, the Target or whatever it is. I don't know. It's a shopping center. They met at a shopping center. They all sat around and talked about what they were going to do. They agreed to do it, and it was an illegal act because it's going to be targeting this church. That is sort of the theory of how it's laid out. And then you start with overt acts. And overt acts, basically, you're just telling the story. Like, this is sort of here's what we would prove if we went to trial to show that this person actually did violate the law.
It's a play-by-play, essentially. And one really interesting thing here, the reason we didn't even tell you really about the background of this, some of you, usually we give you a briefing, even if something's been in the news about it. We want you to hear what is in the indictment. So what was presented to the grand jury and what will have to be proven to the jury. So, I've already learned things from this opening overture of the manner and means of the conspiracy with respect to the people included. So what are the overt acts? So in furtherance of the conspiracy and to accomplish the object thereof, defendants Armstrong, Allen, Kelly, Lemon, Richardson, Lundy, Cruz, Fort, and Austin, together with other persons known and unknown to the grand jury, committed various overt acts, including but not limited to the following. Overt act number 1. On or about January 17th, 2026, defendant Armstrong posted a flyer on 2 Instagram accounts controlled by her, at Nakimal and at Racial Justice MN, advertising an anti-ICE action dubbed Operation Pull Up, telling fellow agitators where to meet to prepare for the operation and exhorting them to, quote, be ready to mobilize. parentheses, ICE refers to ICE, Immigration and Customs Enforcement.
He goes on to say, on or about, this is overt act number 2. So basically, every paragraph's an additional overt act. And overt acts, just so when you allege a conspiracy, there have to be overt acts in furtherance of the conspiracy, right? And so that's what you're seeing here is various people taking actions to move the conspiracy forward. And this is to avoid things like, I mean, my friends and I often talk about how we would have the perfect drug trafficking conspiracy, right? We got like great ideas for how we could do it. We use our expertise to make it happen. We're sitting around talking about that. We're not serious. It's not actually a conspiracy. We're not actually taking actions to further it. We can't be charged with it, right? But when you start having overt acts, like if we went out and bought a bunch of cocaine, then all of a sudden that conspiracy becomes very real. Okay, overt act number 2. And I'll read several of these. On or about January 17th, 2026, defendant Allen posted a similar flyer on her personal Instagram account. Overt act 3, on the morning of January 18th, 2026, all of the named defendants gathered with approximately 20 to 30 other co-conspirators for a pre-operation briefing led by defendants Armstrong and Allen at the parking lot of Cub Foods at 1440 University Avenue West, St. Paul, Minnesota. Number 4, at the pre-operation briefing, defendants Armstrong and Allen advised other co-conspirators, including defendants Kelly, Lemon, Richardson, Lundy, Cruz, Fort, and Austin, about the target of their operation, City's Church, and provided instructions on how the operation would be conducted once they arrived at the church.
So this continues over act number 5. On the morning of January 18th, 2026, defendant Lemon began live streaming on his internet-based show, The Don Lemon Show, where he explained to his audience that he was in Minnesota with an organization that was gearing up for a, quote, resistance operation against the federal government's immigration policies. And he took steps to maintain operational secrecy by reminding certain co-conspirators to not disclose the target of the operation and stepped away momentarily so his mic would not accidentally divulge certain portions of the planning session. Then over act numbers. Oh, go ahead.
I was just going to say, remember, honestly, the non-Don Lemon defendants, this is kind of straightforward, to be honest with you. I mean, you're going to see that. Don Lemon, though, is really interesting because he is this reporter, and he's reporting about everything that's going on. And you sort of imagine, like, what does that mean? And what does it take to sort of go from reporter to conspirator? And you think about, like, I remember, if you've ever read Freakonomics, there's a chapter in Freakonomics about a guy who's like he's like an economics PhD, and he gets lost in Chicago and ends up like in the middle of like a gang meeting, and they're trying to decide whether to kill him or not, right? Because he just like stumbles into the wrong building. It's a great chapter. But then they don't kill him, and he gets to know them, and he becomes like friends with these people, and he learns all this stuff about the drug business, and they're telling him like how it works and how they keep the records and how the money is divvied up and all this sort of stuff. And he ends up writing like a PhD thesis on it. It's really interesting. He talks about the economics of drug dealing, right? If that group was charged with a drug conspiracy, a drug trafficking conspiracy, I think we would all agree that that person, the PhD student, would not be part of that drug trafficking conspiracy, right? I think we all would agree on that. At what point is there anything he could do, though, that might make him part of it? Like, let's say he was walking on the street and he heard some cops talking about how they were going to raid this particular group's hideout. And he gets there for his sort of interview with the leader. And he says, by the way, I heard the cops, they're going to raid your place tomorrow. I just want to let you know that because I really like you guys and you are great. And I want to get the rest of my paper done, right? And so then the group all leaves. The cops show up. There's nobody there. Later on, the police find out about that. Would he be in trouble for that? That feels more like he would, right? And so what you see happening here in the indictment is when they write this, they're trying to show he's not just reporting on it. He's taking sort of affirmative steps to move the operation forward.
And that's a really good point because, of course, in journalism, there's the idea that you don't interfere. If you are truly just there to report, there's always these like National Geographic controversies, right? Like the animal is dying and like all you have to do is pull the baby seal out of the glacier crevice and it will live. But all the National Geographic photographer does is sit there and photograph or video this seal die over the course of many days or weeks. And the defense of that journalist is always, no, we are simply here to observe as if we are not around. But what does this overt act do? What it's trying to do is to say that there are steps, even as he's being a journalist in this Don Lemon show, which I think just streams to YouTube. But again,
Nothing wrong with that.
Nothing wrong with that. But again, the point being that anyone can be a journalist these days. The medium may no longer matter in the way that it would have maybe decades ago. They're pointing out that he's taking steps as he's reporting to not report on things so as not to hinder the operation that he's planning to report on.
And Jason Blair is in the chat. And it's always interesting to hear what he thinks about this, because it's really true that reporters are in this very gray area and often do end up, I mean, honestly, being arrested is almost a badge of honor, right? Like, I mean, I've said this before. I've had reporters try and get me to give them information and say things like, I will go to jail for you. I've literally had reporters say that. I will go to jail for you. Nobody will ever know you told me. And I'm like, number one, I don't want you to go to jail. Number two, I don't want to be involved in this. Right. So yeah, I mean, it's part of what they do. But anyways, you can please continue, Alice.
So over act number 6, during a discussion with Defendant Armstrong at the pre-op briefing, Defendant Lemon thanked Defendant Armstrong for what she was doing and assured her that he was, quote, not saying what's going on, i.e. was not disclosing the target of the operation. And B, Defendant Armstrong explained that Operation Pull-Up was a clandestine operation in which she and other agitators would show up somewhere that is a key location where the targets don't expect us, and we disrupt business as usual. That's what we're about to go do right now. And C, Defendant Lemon said he would see her there. Again, this is trying to take Lemon out of the journalist character, right, I guess.
Move him into conspirator. This statement by Armstrong, by the way, which will be used against her because it's a statement of a party opponent, really bad, right? I mean, she's essentially saying, we are there to disrupt it. Well, that's what's criminalized, is disrupting the church service. So there are various levels of culpability here for different people and various actions, which I think are going to be problematic for some. That's a really bad statement by her, because remember, it has to be intentional, has to be knowing. This seems to indicate that it wasn't just, well, we shut up for protest. We didn't realize it ruined the whole service. It's like, no, we wanted to disrupt the service. Okay, so it goes on. Over to act number 7. Before heading to the church to join his co-conspirators, Defendant Lemon advised his live stream audience that we're going to head to the operation. Again, we're not going to give away any of the information away, i.e. operational details that would disclose where he and his conspirators were heading. Over to act number 8. At the pre-op briefing, Defendant Allen led other co-conspirators in chants that they would use at the church, including, "This is what community looks like," and "Ice out of Minnesota." Urged her co-conspirators that they have to have a duty to fight for our freedom and a duty to win. And C, as the group prepared to head towards the church, directed her conspirators to stay bumper to bumper, make sure everybody gets through the light, can confirm that everyone had the address. Over to act number 9. At the pre-op briefing, Defendant Armstrong provided instruction and operational guidance to her co-conspirators, including the following. A, the first wave of agitators should enter the church essentially in an undercover capacity and position themselves around the church sanctuary. B, they should not sit together and should not wear anything that is activist identifying. And a lot of this is quoted. And C, those who had anything activism identifying, it's all quoted, should wait and come in with the second wave.
Sounds like they got a hold of like the instruction sheet, whether it was a text or, something sent out. It goes on to say overt act number 10. Continuing on the morning of January 18th, 2026, all of the defendants got in vehicles and traveled with their co-conspirators to the church to engage in the planned takeover style operation. Again, this is to show that they took steps to carry this out. They didn't just like wake up at the church. They could choose not to be part of this conspiracy, but they all chose to be a part of this. Over act number 11, when en route to the church, Defendant Richardson told Defendant Lemon that they had to, quote, catch up to the others, and Defendant Lemon replied, quote, let's go, catch up. And because he was still live streaming, Lemon instructed Richardson and an unidentified male, quote, don't give anything away, i.e. don't divulge information about the operation, and advised his audience, quote, we can't say too much. We don't want to give it up. Over act number 12. Continuing on the morning of January 18th, 2026, all of the defendants, together with other co-conspirators, entered the church sanctuary, with the first wave positioning themselves among the congregants, and the second wave, led by defendants Armstrong and Allen, commencing the disruptive takeover operation, in which the first wave of agitators then actively joined.
All right, overt act number 13. As the pastor was beginning his sermon, defendant Armstrong interrupted the service with loud declarations about the church harboring a director of ICE and indicating that the time for judgment had come. And other co-conspirators immediately joined in by yelling and blowing whistles in a takeover attack on the church, all of which quickly caused the situation in the church to become chaotic, menacing, and traumatizing to church members. Now, remember, these are allegations, right? And you can see where up to this point, it's been very sort of fact-based. Like, she said this, she did this, he said this. Well, now we're starting to put a little bit more color into it, and you're just going to have to decide for yourself. Are these things menacing? Are they traumatizing? Et cetera, et cetera.
And they probably put this in there, just so you know, is because they interviewed members and they're able to put up witnesses for this. But remember the statute. You don't actually have to show an injury. You just have to show interference, right?
Right. Overt act number 14. While inside the church, defendants Armstrong, Allen, Kelly, Richardson, Lundy, Cruz, and Austin, and others led and or joined with their co-conspirators in various chants, including ice out, hands up, don't shoot, and stand up, fight back, while gesturing in an aggressive and hostile manner, which congregants and the pastor perceived as threats of violence and a potential prelude to a mass shooting. Recall, it's all about what does the person there, what is their reasonable fear, right? Like, if they're in reasonable fear, then that fits the statute. I mean, that's the way it's been interpreted. So, we've seen mass shootings in churches before. Obviously, this is a difficult situation. Now, one thing I want to note about this, we listed a whole bunch of people, didn't list Don Lemon. So it seems like, at least for overt act 14, and this is a big one. I mean, this is one that supposedly is really instilling fear in the congregants. Don Lemon's not listed. So it appears, even from the allegations in the indictment, he is not doing the chanting in the middle of the service.
Over act number 15, while inside the church, defendants Armstrong, Allen, Kelly, Lemon, Richardson, Lundy, Cruz, Fort, and Austin oppressed, threatened, and intimidated the church's congregants and pastors by physically occupying most of the main aisle and rows of chairs near the front of the church, engaging in menacing and threatening behavior for some, chanting and yelling loudly at the pastor and congregants, and or physically obstructing them as they attempted to exit and or move about within the church.
Now here, Lemon is listed because this is more the physically obstructing thing. And frankly, it's just, he was in there, right? He was in there. He was in the aisles. He was around the pastor. So is that enough to be sort of the obstructing aspect of the statute?
And that's really interesting, because the only qualifier for all these different behaviors, the menacing, threatening behavior, is the chanting, which they put in parentheses in the indictment for some, because I think the for some is that except for Lemon. And the reason we probably know this is we have the live stream going, and likely he's not yelling into the microphone. He's probably videoing it and not participating in the chants, is my guess. I haven't seen videos.
I find the for some thing, like, if I were writing this indictment, I would not. That's so vague.
I know.
Like, what do you mean for some?
I would say like including, but not like.
Yeah, I mean, the named people who did it.
I think it's because of Lemon, though.
I do too, but I still think it's like.
But they wanted to put Lemon in this overt act,
right? Because they need to. Like, he needs to have done something other than just
have obstructed. This is the statutory language,
right? And you can see, and this is just interesting for those of you who are interested in the way indictments work. You can see how the indictment is attempting to grab on to various parts of the statute itself. Overt Act 16. While inside the church, defendants Austin stood with other agitators in and around the main aisle in the church to intimidate the church members and obstruct and interfere with their freedom of movement, approached the pastor and congregants in a menacing manner, and near the end of the operation, loudly berated the pastor with questions about Christian nationalism and Christians wanting to have their faith to be the law of the land. Overt Act 17. While inside the church, defendant Lundy personally participated in the disruptive takeover operation with other defendants by standing in the main aisle with the others and contributing to the physical obstruction and intimidation of the congregants, participating loudly in some of the chants, one saying that the targeted ICE agent must be out, and punching his fist in the air. While inside the church, This is sort of getting an act by all the various people listed. While inside the church, defendant Cruz personally participated in the disruptive takeover operation with other defendants by standing in and around the main aisle with the others and contributing to the physical obstruction and intimidation of the congregants and participating in some of the chants. Overt Act number 19. While inside the church, defendant Kelly disrupted the service by chanting, "This ain't God's house. This is the house of the devil," approached one female congregant who was with 2 young children and demanded to know in a hostile manner why she was not involved in and supportive of the takeover operation, screamed Nazi in congregants' faces, and asked child congregants, "Do you know your parents are Nazis? They're going to burn in hell." Not great facts for Kelly.
Not great facts.
Yeah.
Then goes on to say defendant Lemon told his live stream audience about congregants leaving the church and about a quote young man who Lemon could see was frightened, scared, and crying. Not great because it's from the own defendant's mouth that they're making people scared. And Lemon observed that the congregants' reactions were understandable because the experience was, quote, traumatic and uncomfortable, which he said was the purpose. This is like directly to the statute. None of this was an accident. It was foreseen. It was the intended consequence.
What's interesting of this, before you get into this, the fact that Lemon is named as a defendant, even if he ends up being acquitted, means all these statements of his come in. Because they're all statements of a party opponent. So his sort of observations of what's happening will be evidence.
Relevant, right?
Yeah, in the thing. So,
and that was going to be something I said at the end is like, strategically, even if it's a weak indictment against Lemon, I don't know. We'll finish reading it. You can decide. It may strategically, evidentiarily be a good move because of the direct quotes and all of the live streaming evidence that would be able to come in, because obviously Don Lemon is not going to be a very friendly witness for the government should they call him for, testimony. Okay, it goes on to say, as the operation continued, defendant Lemon acknowledged the nature of it by expressing surprise that the police hadn't yet arrived at the church and admitted knowing that, quote, the whole point of the operation is to disrupt. Hello, disrupt, interfere. That's the statutory language. Overt Act number 22. While the takeover operation was underway, defendant Lemon asked defendant Armstrong, who is the person that we should talk to? Is there a pastor or something? And she pointed toward the front of the church, but noted the pastor, quote, might have run away.
Overt Act number 23. While other co-conspirators standing nearby, defendants Lemon, Richardson, and Fort approached the pastor and largely surrounded him to his front and both sides, stood in close proximity to the pastor in an attempt to oppress and intimidate him, and physically obstructed his freedom of movement, while Lemon peppered him with questions to promote the operation's message. Once again, some real
this is interesting, right?
I mean, yeah, is he...
So they're not chanting along, or is he being a journalist?
Exactly. It's like the end there to promote the operation's message. I mean, I don't know. Like sometimes you build weaknesses into your indictment, and I almost feel like this is one. Like you had the whole he's standing near the guy, he's blocking the guy, he's blocking the aisles, he's talking about how the whole point's to disrupt. But now he's just asking questions. I mean, arguably now he's in a very journalistic role when he's talking to the pastor.
So while talking with the pastor, defendant Lemon stood so close to the pastor that Lemon caused the pastor's right hand to graze Lemon, who then admonished the pastor, please don't push me. Although the pastor told defendant Lemon and the others to leave the church, defendant Lemon and the other defendants ignored the pastor's request and did not immediately leave the church. After causing most of the congregants to flee, some of the defendants and other agitators engaged in a chant proclaiming, quote, who shut this down? We shut this down.
Some really stupid things. I mean, there are lessons to be learned here if you're a protester. Don't say things that are basically we broke the law. We broke the law, right?
Maybe say things like, you did this.
Right, exactly.
your actions did this.
You are bad, right? We're not bad. I don't know. It's just, it keeps going. Okay. As one congregant reported to responding police officers, some of the agitators blocked the stairs leading to the church's child care area and made it difficult and hazardous for parents to retrieve their children, causing some to take alternative routes in and around the church. Overt Act 28. At one point, defendant Lemon posted himself at the main door of the church where he confronted some congregants and physically obstructed them as they tried to exit the church building to challenge them with facts about U.S. immigration policy, or I'm sure he would say, to interview the people there about what had happened and sort of their views about what happened or whatever. I mean, imagine if Don Lemon had shown up. Imagine he had heard on the police scanner this was happening, and he speeds over to the church, and he gets there as people are starting to leave, and he gets up to the front door, and he starts doing the exact same thing, asking these questions. I think at that point, I don't think anybody would say he was breaking the law. You got to tie it all in to everything he was doing before, the fact he was at the pre-meeting, et cetera, et cetera. I don't know. It's gonna be a close thing on him. A verdict number 29. As a minivan full of children were preparing to depart from the church, defendant Kelly walked in front of the minivan and angrily yelled at the occupants, and defendants Armstrong and Fort stood in front of the minivan while Fort interviewed Armstrong. Okay. So that's basically the end of it. They then go on, they restate, the count 2 is basically the same thing. It's the
instead of a conspiracy, it's
a substantive act. Yeah. So, and by the way, though, if you read count 2, if you look at count 2, if they'd only charged count 2, this is what the indictment would have looked like. Right?
So like a page.
Yeah, it'd have been a page long, wouldn't have had any of that
recitation of the statute, like intimidate, interfere, that whole thing.
Right. And that is a strategic decision by a prosecutor to charge a conspiracy so that you can do the overt acts. And so they're doing that on purpose so they can lay all that out, because an indictment is a charging document, but it often is also a public speaking document. And so by charging both, you're getting all those overt acts in, which you wouldn't get if you only charged the substantive offense.
And they have to know when they're charging this, and you're charging someone who is a journalist and who is well known in, like, beyond the people who just know the other co-conspirators, that you're going to get pushback. So this is your way to essentially defend to the public what's going on. Now, whether it actually did that or not is up to you all to decide. But that's another feature of this. You can imagine if they just went in and arrested Don Lemon with an indictment that was a recitation of the statute, 2 lines long, there probably would be a lot of uproar. Like, what is there? What do you know? Now, actually, there's something to grapple with respect to what is the evidence for charging Lemon and all the other co-conspirators. And like you said, whatever you think about the FACE Act, I think the other 8 co-conspirators who are not Lemon, who are just individual civilians, who helped plan this, who went there, who did all the chanting. Lemon is really the only one who is singled out at any point in any of the overt acts to have done something slightly different, because he is live streaming this. It is pretty slam dunk. This is what the FACE Act was for. They did do the things because of the broadness of the statute with respect to interference, and their own words that they meant to interfere, and they in fact did interfere, and that people were frightened because they can see it, and it's understandable why they're frightened, and why didn't the police come, because the whole point is to disrupt everything. All of that is pretty straightforward with respect to the other co-conspirators.
Okay, so I mean, there you have it in large part. I mean, that is the charge. It is the indictment. You can decide for yourself if those accusations are true. Are they guilty? Once again, I would urge you attempt to distance yourself from the politics of it. I mean, because at the end of the day, it doesn't actually have anything to do with ICE or not ICE. The question just is, can you do this? I mean, can you go to a church service and do this for whatever reason, whatever your otherwise constitutionally protected reason? I think that's really important, because what they're doing is constitutionally protected speech in a different circumstance. Absolutely could do this in a march. And I think you need to also remember, I think it's important to remember how broad the rights of people to protest are. And I pointed this out on Facebook. The seminal First Amendment protest case, Brandenburg, is a case about the Ku Klux Klan. It was a case about how a Klan leader shouldn't have been charged for spreading Klan paraphernalia. And, there's Supreme Court cases about the Klan marching in like Skokie, Illinois or whatever. Right. So like, think about that, because the people you don't like have free speech rights as well. Should they be able to bring those to places like synagogues? Should they be able to come protest at a synagogue? Should they be able to protest? I mean, you can imagine it's not hard to come up with scenarios with people with ideas that you don't like, that you think are really bad, that nevertheless have the right to express those, going to places that are otherwise protected to express those ideas, should they be able to do that.
So that's a really good point. The reason this is an indictment, and by the way, this went to the grand jury, which means it was heard by a grand jury of a number of people who have been called to jury duty, and they heard evidence that would support this, and they issued a true bill, which is what allowed this to be an indictment.
But you go ahead, and then I'll
Okay,
have one other comment about that.
with what other happened with it.
Yeah.
But that's a really good point, because this is only an indictment, only a charge because it happened in a house of worship. They could have done all of these things outside of the church, on the streets. We've actually seen a lot of protests recently, right? Lots of protests happening. Basically every city I've been to, there's been a protest. And that is, for the most part, depending, of course, how you're conducting yourselves. But basically all the things they're saying, except for maybe standing in front of cars, depending on where the cars are, that sort of thing, and what the intention is, and whether there's like a physical harm coming to people. If they were screaming all of these same things outside of the church, in the parking lot even, it's likely constitutional and no problem, and no violation of the FACE Act here. But that's a good point about this actually going before a grand jury, because it took a circuitous route to where it ended up today.
Yeah. And I'll just say, I mean, I just think you should be able to go to church if it's happening to you. I mean, and I think that's the point of the FACE Act. I think you should be able to go to a synagogue without having Nazis show up. I have prosecuted one of these cases, and it was during the COVID period, and a synagogue was having an online service, and there were people who came into their online service and started saying things like, we're going to finish what the Nazis started, this time the Holocaust is going to be real. Like, they were saying that kind of stuff during this Sabbath service. And we found those people because it wasn't not hard to find somebody's IP address, and did what we could with that. I don't feel like we violated those people's First Amendment rights. I mean, I think they got exactly what they deserved, right? And I think those people in that synagogue had the right to have their service without somebody expressing their views, whatever those views are. And one thing that's interesting about this case, and just to give you sort of an idea of how things can work, before the government took this to a grand jury, they attempted to file a complaint. I don't really know why they went the complaint route. I mean, typically,
not with the speaking indictment. Like, they clearly had already done all the evidence.
There's a lot about this. I mean, number one, you have all these different defendants, one of whom is a journalist that raises sort of interesting issues. Complaints are typically sort of emergency type things. Like, we know somebody's dangerous. We don't have time to wait for the grand jury. We're going to file a complaint, go before a judge, get an initial probable cause finding. Then we have to have a hearing after that to establish probable cause, which you'd almost never really want to do unless you have to. It's a bizarre sort of decision to try and go that route. Initially, some magistrate judges pushed back on this, wouldn't return the indictment or the complaint. For some reason, the government attempted to mandamus them, which is not the appropriate remedy, to the circuit. And the circuit was like, there are the ways you can do this.
Go to the grand jury.
Yeah, why are you trying to mandamus this?
I mean, I think I know why, right? I think they were afraid of the grand jury because of the temperature in Minnesota. I mean, I don't know that for a fact, but I think that may have factored into it. And so thinking, like, this is kind of like why you choose to go for a bench trial or a jury trial. You're like, well, the temperature is too hot right now. I'd rather go with like a one judge determination.
Yeah. So I don't know why they did that. It kind of blew up in their face. It didn't look good.
Did not look good.
They proceeded to grand jury, and none of that matters, right? I mean, there were people online who were like, was the grand jury made aware that a magistrate judge rejecting a complaint? Well, no, because it doesn't matter. The only question is there facts and evidence sufficient to establish probable cause? And the grand jury found there was. I expect the way this is going to go, I would think probably some guilty pleas. I mean, there'll be some attempts to get the indictment dismissed. There'll probably be a constitutional challenge. Supreme Court's never considered this act, So even though the circuits have generally upheld it, you can still challenge it, particularly on Don Lemon's part. I mean, Don Lemon has the strongest case, not just because he's a journalist, but because his involvement is very journalistic. He is sort of there reporting, and that question of whether he goes too far is a difficult one. So I would imagine Don Lemon, number one, will have the strongest constitutional challenge, but number two, also probably has the best jury case. I mean, he has the best sort of jury argument. So I think if Don Lemon, this is either going to get dismissed against him or he's going all the way. I mean, I don't think there's any in between. I think a lot of the other people probably plead guilty to some misdemeanor
because they're loose. This is not actually like a drug conspiracy where all the people know each other very well. They probably met once in that parking lot before, the day before, the day of.
I mean, I think Armstrong probably has the most liability. I think it seems like she was
the leader,
the organizer, the leader, the one who confronted children, has some really bad facts for him. But it'll be interesting to see how it goes. I mean, there'll be some cool for law nerds legal wrangling about this, and then we'll just have to see what happens. Might end up being a Supreme Court case. And if it is, I mean, honestly, this would be a great Supreme Court case in a lot of ways, because you could do some more First Amendment work. You could talk about more stuff on content neutral restrictions, journalist stuff. I mean, there's a lot here. So I don't know. This one may be one that we have to come back to in a year or so if the Supreme Court ends up involved in it.
Well, this has been fun. I might not be able to answer a question today because I might be barely upright.
All right, somebody just asked what the penalty is. Let me see if
that's a good one. It's probably not that high.
Okay, so it's okay. So the first offense is punishable by up to 6 months or up to 1 year. So that's a misdemeanor for first offense, which I think this would be a first offense for everybody. So pretty low. I think a conspiracy to commit a misdemeanor is still the misdemeanor. So, I mean, honestly,
if there's been a violation of the FACE Act, there's a violation of the FACE Act, but it's also because of the egregiousness. And obviously this is not the first of, this is in the midst of a lot of things happening, right?
I mean, I think it makes sense to say, hey, whatever is going to happen, it don't need to be happening in churches, right? Yeah. So I can see why you bring it. And it's one of those things where the first offense is a misdemeanor and subsequent offenses are felonies. So, and you see that with some stuff where kind of give you a little bit of a pass the first time, but then if you continue to do it, it piles up on you. So anyway. All right. Well, Alice is barely with us, so we're not going to answer a question today, but she made an hour. I thought this was going to be a short one, of course. And of course it wasn't.
Never.
Shoot us an email. If you have things there's a lot of stuff going on in the world. If you have legal questions you want us to address, we're happy to address them. We fear no issue. So we're always happy to talk about these things. I look forward to your 1-star reviews because I'm sure some will follow this because some people are incapable of just discussing the law. But let us know if you want to know more about this or any other issue. We're not answering questions today, but if you leave a 5-star review and leave a question, we will answer those for you. prosecutorspod@gmail.com is email. @prosecutorspod for all your social media. Join us on the gallery to discuss this and other issues. If you want to watch us record these early live, $3 on Patreon. If you want to get these early and ad-free, also $3, and you don't even have to see our face. So I think that's all the business, Alice. If you want to go ahead and sign us off for today.
That sounds great. Thank you, guys. Hope you enjoyed this conversation and decide for yourself. Read the statute, read the indictment. But until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs.
Good work, Alice. You made it. You survived. Now you get the whole weekend off. I won't even make you record tomorrow.
Whew.
Okay, don't forget to stop.
I will forget to stop. It's funny last night because, like you said, whatever this is, like you feel I didn't feel better. I never felt better. But around like going to sleep time, and I don't think it was because I was laying down because I was upright because I'm so congested. All of a sudden, it felt like I was dying. Like
Mm.
I was coughing. I was like, oh, I'm dying. This is how I die.
It's always the worst
I know, at night.
at night.
And so I woke up
Yes.
with no voice. Okay, what is this? This is, let's call it Don Lemon
I just said
indictment.
Don Lemon. Yeah.
Great.
Oh, Don's best thing ever happened to him.
It.
Don had sort of faded off into the.
I know.
Now he's back.
Forgot about him, to be honest.
I mean, I did too. I was
Because
like,
I think
wait,
he's only on YouTube, right? I don't think
Yeah,
he's
not
because he
that
got
there's anything
fired.
wrong with that.
He got no,
keep
nothing's wrong with YouTube.
attacking
But he had
YouTube.
met with some, difficulties in his career.
Yeah,
Now he's back.
he's back.
Okay, I'm gonna go get a hot compress.
You do
and
that.
Hot water. That's
All
really
right,
good to
guys.
see.
Love you, mean it. We'll see you soon. Take care.
Bye, y'all.
Bye.
Bye.